Okay, we're going to go ahead and get started. Good afternoon, everybody. It's a pleasure to be here with you today. My name is Chloe Zoeller, and I'm the Accountability Lead at the Pan American Development Foundation. In this capacity, I represent our organization as the sub-chair for Latin America on the Global Targeted Human Rights and Anti-Corruption Coalition. I'm happy to be accompanied here today by my counterparts who serve as the jurisdictional co-chairs of the coalition. We have Amanda Strayer of Human Rights First, Natalie Lucas of REDRESS, Mutasim Ali of the Raoul Wallenberg Center for Human Rights, and Gita Tsertsvadze of the Open Society, not European Policy Institute, Europe and Central Asia. Together, our organizations coordinate and lead a coalition that works with more than 300 civil society organizations across the world, explaining how targeted sanctions work and how these tools can be used to promote accountability for human rights violations and corruption. Today, we'll be sharing this knowledge with you, as well as discussing possible routes for improving the use of targeted sanctions to specifically address corruption. Targeted sanctions, for those who don't know, are often referred to as Magnitsky-style sanctions, and they are tools that governments can use to issue visa bans and asset freezes, as well as publicly denounce serious human rights violators and corrupt officials. Once an individual or an entity is sanctioned by any given jurisdiction under the Magnitsky mechanisms, it is illegal for any persons within that jurisdiction to transact or do business with them. These mechanisms were named after Sergei Magnitsky, a Russian lawyer who, in 2009, was detained, tortured, and ultimately murdered in prison after having revealed a corruption scheme involving high-ranking government officials. Since the original sanctions were imposed against those responsible for Magnitsky's death, the U.S. has sanctioned over 420 individuals and entities for human rights abuses and corruption. Other jurisdictions have since followed suit, with Canada sanctioning over 320, the UK 108, and the EU 23. While these mechanisms are not meant to replace justice at the national level, they do offer a unique opportunity to call attention to unjust power structures, patterns of criminality, and state complicity in systemic human rights violations and acts of corruption, especially but not exclusively in parts of the world where impunity reigns supreme. Civil society organizations play an indispensable role in monitoring, documenting, and condemning corruption at all levels and across every sector of society. Today's panel will serve to acknowledge this work, as well as elaborate on how the existing targeted sanctions mechanisms in our respective jurisdictions can and should be utilized to hold individuals, entities, and networks accountable for their crimes, ultimately promoting more just and transparent societies. After 5 years of Magnitsky-style sanctions, much progress has been made in both the quality and quantity of designations. But still, there's a lot of room for improvement in the development and use of these tools. These sanctions, while powerful when issued unilaterally, become even more consequential when various governments work together to target the same perpetrators. And as such, multilateralized sanctions should be deployed whenever possible to ensure maximum impact. To date, governments with these mechanisms have displayed a willingness to multilateralize sanctions against human rights abusers, but are far less likely to do so in cases of corruption. Furthermore, while the US, UK, and Canada all possess Magnitsky-style corruption mechanisms, the European Union can't yet claim the same. So it is imperative that the EU join its allies in creating and putting to use a corruption mechanism to further reduce and disincentivize the use of Western financial systems as safe havens for criminal profits. Our panelists will each give us an overview of their respective jurisdictions' mechanisms for corruption sanctions, as well as discuss how civil society can access these tools to promote accountability. They will also share examples of the promises of these mechanisms, in addition to highlighting paths for improving their implementation. After their initial interventions, we will begin with some questions and then open it to the public for a lively discussion. We will also all stick around for a few minutes after the panel should you guys have any private questions or would like to exchange information. So without further ado, we're going to get started, and I'm going to begin by introducing our panelists to kick off the session. As Supervising Staff Attorney for Accountability at Human Rights, Amanda Strayer coordinates a coalition of more than 300 NGOs using the Global Magnitsky Act and targeted sanctions authorities to hold corrupt actors and human rights abusers accountable. In this role, Amanda serves as the primary liaison with the U.S. government personnel and assists NGOs and pro bono attorneys preparing recommendations for sanctions in Africa, the Near East, and Europe and Eurasia. She also helps lead the organization's research and advocacy in the use of targeted sanction tools to respond to corruption and human rights abuses. Previously, Amanda worked at the Robert F. Kennedy Human Rights, the South African Human Rights Commission, Women for Women International, and others on various human rights issues. She received her JD and a certificate in refugees and humanitarian emergencies from Georgetown University Law Center and a BA in foreign affairs from the University of Virginia. Thanks for being here, Amanda. Natalie Lucas coordinates REDRESS's work on corruption sanctions in collaboration with the UK Anti-Corruption Coalition. In this role, Natalie assists partners in the development of sanctions recommendations, promotes the effective use of the UK's sanctions regime to relevant stakeholders, and conducts workshops for civil society organizations. Previously, Natalie worked as a visiting professional in the trial chambers of the International Criminal Court. She also spent 5 years practicing at White & Case LLP, where she represented clients in complex international arbitration and litigation proceedings. Throughout her career, she has maintained a busy pro bono practice, including, most recently, managing a project preparing submissions and urgent appeals to the special procedures of the UN Human Rights Council on behalf of victims of serious human rights abuses in Southeast Asia. Natalie is a qualified solicitor in England and Wales and holds an LLB with honors from the University of Exeter and an LLM in international law from the University of Cambridge. Mutasim Ali is a legal advisor at the Raoul Wallenberg Center for Human Rights with distinguished career in human rights activism both in and outside of Sudan. Previously, he worked as a legal consultant for Project Expedite Justice, Civitas Maxima, and has done counseling work for the International Criminal Court. Mutasim is a graduate of an LLB in General Laws from Academic College of Law and Business in Israel, and a graduate of an LLM from George Washington University Law School, majoring in international and corporate law. He has been recognized as a distinguished student for exemplary studies in international human rights through the law school. Finally, Gita Tsertsvadze is a senior policy analyst on EU external relations at Open Society, Europe and Central Asia. She is responsible for EU foreign policy and sanctions policies, analyses, and advocacy. Through her work, Tika provides training and support to NGOs and civil society actors looking to submit sanctions recommendations for considerations by the European Union. Prior to this role, Tika worked for the International Partnership for Human Rights and think tank FRIDA. So now that all the panelists have been introduced, we're going to go ahead and give each of them a few minutes to give initial remarks and explain their jurisdiction's roles and targeted sanctions. So I'd like to begin with Amanda, Human Rights First, who will discuss the U.S.'s use of global Magnitsky sanctions for corruption.
Great. Thank you, Chloe, and thank you all for joining us this evening. So I'll go ahead and give a little bit of history on the global Magnitsky sanctions program as it exists in the United States. I'll talk a little bit about how it's used to address corruption situations of corruption around the world, and then close out with a little bit about the role of civil society in bringing forward recommendations of individuals and entities who would be eligible for sanctions. So a bit of background for you all. The Global Magnitsky Program in the U.S. Originated with the Global Magnitsky Act in 2016 and an executive order that followed the next year in 2017, and really was the first jurisdiction to introduce the concept of global Magnitsky-style sanctions, and was quickly followed suit by the other jurisdictions you see represented up here. The program is unique because it allows for targeted sanctions against particular individuals, particular entities. It's much more narrow and tailored than sanctions programs of the past that were maybe more countrywide or targeted entire economic sectors. These types of sanctions are meant to really ensure that the consequences of the sanctions fall on those who are most responsible for the problematic behavior. They are global in scope, as the name implies, so that means they can be used anywhere in the world, in any country, and they apply to both situations involving human rights abuses and corruption. Some of the different jurisdictions structure this a little bit differently, but I think there is a recognition that a lot of the problematic situations that are confronting us around the world have elements of both types of abuses occurring. And so being able to have programs that can address both and can combine both is really important. As Chloe mentioned, in the past 5 years, this tool has been used more than 420 times and across 40 countries in the U.S. It's been used in pretty much every region in the world, which is really great and living up to its name of being a truly global program. So to dive a little bit into giving you a sense of what do we mean when we say this program is meant to address corruption. The program covers both financial corruption that has a government nexus to it, but it also includes things like more quid pro quo style corruption, as well as more broader systemic state capture related issues. It covers things like money laundering, fraud, misappropriation of state assets, corruption in government contracts or extraction of natural resources. It's a very broad authority in the United States, and we've seen it used that way across the world to address a wide range of different types of corrupt situations that are of concern. Because these tools are reaching their 5-year mark, our organizations earlier this year, last month actually, released a report on multilateral Magnitsky sanctions at 5 years, which is the first report that really takes a deep dive into how these programs are used and what the gaps are in these programs. We wanted to try and underscore and identify the gaps because we want to be able to go to our respective jurisdictions and governments and say, here's what you need to do to address and use these tools more comprehensively and more equitably. But we also wanted to use the report as an opportunity to help NGOs and civil society better understand how these tools are used and to make more effective use and engagement with these tools themselves. So from that analysis that we did, it was a months-long analysis. The report's online. Highly encourage you guys to check it out if you're interested. But we found that the U.S. to date has issued the largest number of sanctions and of corruption sanctions in particular among the 4 jurisdictions. There have been over 285 times that they've sanctioned people for corruption or entities, and 14 times that they've sanctioned for both corruption and human rights abuses. Again, recognizing that some individuals are involved in both corruption and those types of human rights abuses. And of all of those nearly 300 corrupt actors who were sanctioned, these are spread across 40 different incidents. So it's spread across every region of the world. There's a broad mix of different countries, countries that share different types of different types of how, whether they're considered free or not free or partly free, based on external metrics. And there's the numbers I think really show and bring to bear the approach that the U.S. government has taken to corruption sanctions has been a more network approach. They are looking not just at isolated individual corrupt actors to target and to take down, but really looking at what is the network of individuals and entities that this person or these few people use to enable their corrupt actions, to launder money, to engage in bribery, to engage in corruption in government contracts, et cetera. This network sanctions approach, I think, is one of the hallmarks of how the U.S. government has been using their corruption sanctions authorities under global Magnitsky to date. On average, they're looking at about 7 sanctions per incident, so 7 individuals or entities sanctioned per incident, but these can grow to be much larger. We've seen a number of designations that tackle networks the size of 40, 50, nearly 60 entities and individuals. So, for example, in Bulgaria last year, they sanctioned several Bulgarian oligarchs who were alleged to be involved in corruption, and then dozens of entities that they owned or controlled or that they were using to help further their corruption. And so, that network, again, is something that is, I think, very central to the U.S. government's idea of how to address corruption. It's not just about going after the individual, but about trying to take down a network comprehensively all at once. And we often see the U.S. government follow the network. We've seen in a number of situations of corruption where, for example, with sanctions against Dan Gertler and affiliated individuals and entities in the Democratic Republic of Congo, the Treasury Department came out very strong with an initial round of sanctions numbering around, I think, 20, 30 some. And then we've seen consistently over the years new designations coming out related to his network as they continue to identify new associates who are involved in providing some sort of assistance to the corruption, or new entities that appear to be involved in the corruption. So we see that the Treasury Department continues to stay on track and to follow the network as it tries to navigate around the sanctions, if you will. And a lot of times these are international networks as well. They're not looking at just isolated incidents in one particular country, but we see a number of times where these networks involve actors in a particular country, shell companies or other entities outside, sometimes in other places in Europe or the UK or elsewhere, and the US really trying to follow those trails and ensure that that entire network is taken down. I think, part of this hallmark of the network sanctions approach for corruption is borne out by the fact that there's very large numbers of entities, of businesses in particular, that the U.S. government have sanctioned, and a real mix of state and non-state actors in that. So that's just kind of a bit of a snapshot of some of the ways in which our report showed how this tool is being used to date. And I think what has also borne out in the data is the fact that civil society has been somewhat of an unsung hero in this process. They've played an incredibly important role in bringing forward information to the U.S. government that allows them to then turn around and issue sanctions designations against individuals and against corrupt networks. As of today, about a third of all the U.S. government sanctions across both human rights and corruption in the Global Magnitsky program have a basis in civil society recommendations, meaning we can look at a third of U.S. Global Magnitsky sanctions, and we know that civil society groups provided information on those issues, on those perpetrators to the U.S. government, and that it appears that they've taken that into account and acted on that. So this is, civil society plays such a hugely important role in identifying these situations, in bringing to light situations of corruption, in finding the names and identities of the particular perpetrators of corruption, of uncovering the networks of businesses that they are own or control or are involved in. And all of that is so critically important to the U.S. government for them to be able to effectively take down these networks. I think I'll close too by saying that it's important to remember for civil society groups that are doing this kind of documentation work and are thinking about, interested in potentially providing this information to the U.S. government and the potential impact that could have within the situations that you're looking at. It's important to also understand that documentation of the abuses is step one, but there's also a huge consideration to bear as well in terms of remembering that sanctions are policy tools, that they are used at the discretion of the U.S. government and of all of the governments that we work with. And so thinking as civil society advocates, not only about documenting the abuses and getting the accurate information and uncovering all of that, but thinking too about what are some of the policy reasons or rationales why the U.S. government should be paying particular attention to this corrupt network or these corrupt individuals. What are some of the reasons that we can bring forward to help strengthen the case and really argue for the U.S. government to take this step? Because unfortunately, it's a very there's a lot of human rights abuses going on in the world and a lot of corrupt actors in the world. So there's no shortage of potential sanctions targets, but also thinking a bit strategically about what types of issues might align with U.S. foreign policy goals is something that we're collectively working with groups to help hone as well. So I'll go ahead and stop there and turn it back to Chloe for now, but looking forward to our discussion today.
Thank you, Amanda. Next up, we'll have Natalie. Okay, let's applaud her. Next up, we'll have Natalie of REDRESS to talk about the UK corruption scheme.
Thanks very much. Welcome, everyone. So yes, I'm just going to discuss a little bit about the UK's specific scheme. So it's quite a bit newer than the US's. The UK's global human rights sanctions regulations came into place in 2020, and their anti-corruption scheme came into place in 2021. So it's quite a bit newer than the US. The reason for that regulation was obviously because of Brexit. So it's been interesting to see how the UK has developed its policy in relation to sanctions over the last couple of years. Since the regimes were brought into place, 108 designations have been made in total by the UK. Of these, only 27 relate to corruption. So as Amanda was saying, and as we've alluded to earlier, we are seeing a lot less designations being made for corruption than we have for human rights abuses, which is concerning, and also definitely shows a place where countries can do more and should be doing more in relation to this space. Of this, only 6% of corruption cases have been coordinated multilaterally, so coordinated between 2 or more jurisdictions. The UK in particular has been not too bad in relation to this. We've seen some coordination, in particular in relation to the Gupta brothers, in relation to corruption in South Africa, Al Cardinal in Sudan, and a few cases in relation to Latin America. The UK is also coordinated with Canada in relation to Russian fraud, in relation to the Russian fraud scheme, which was uncovered by Sergei Magnitsky. But we've seen a real drop-off in terms of coordination and any new sanctions by the UK government since 2021. And in fact, no new corruption designations have been made this year. This is partly because, obviously, there's been a renewed focus on Russia. The UK uses country-specific regimes a little bit more often than it uses its thematic regimes. And so our report, looks specifically at Magnitsky regimes because corruption goes beyond just the sort of country-specific, and so that's what we've been advocating for. So just to talk a little bit about why coordination is so important in terms of tackling corruption. The type and scale of corruption that these regimes can tackle is very complex in its nature and is often international. And so one country taking action using its sanctions regulations will have less of an impact, we would say, than a couple of countries taking action. We think that the UK should really be using these regimes consistently to target networks as a whole. So as Amanda was talking about, targeting of corrupt networks. Currently, the UK has only targeted 27 individuals and entities, but we would like to see a sort of larger, more network-focused approach being taken. For example, as Amanda said, the Dan Gertler case, where the US sanctioned not only the individual himself, but 47 associated individuals and entities, therefore really disrupting that corrupt network, at least so far as US jurisdiction is concerned. We would like to see a sort of more coordinated approach taken by the UK and others in making sure that these international schemes are being targeted properly and that they're being dismantled. Now, the Magnitsky legislation in the UK is capable of doing this. Whilst it's a slightly narrower focus in the type of corruption which it tackles, which we'll probably discuss later, it does have the ability to tackle enablers and facilitators of corruption, not just the individuals at the top of a scheme. Right now, with the number of designations we're seeing, these sorts of schemes aren't being completely dismantled, but when used appropriately and more robustly, then we would sort of see these schemes being tackled more closely. In terms of NGOs' role to play within the UK, the UK legislation and approach has sort of mirrored some of what the US has done, and so like in the US, NGOs are able to submit information to the UK government recommending individuals and entities for sanction. And this is something that we help facilitate with our partners globally. And where possible, we try and coordinate submissions which have been made to one jurisdiction to make sure that other governments have sight of the evidence and can take action if they feel it is appropriate. Obviously, as in the US, Magnitsky legislation is primarily a foreign policy tool. So whilst there are sort of legal tests that need to be met, one of the biggest hurdles is the foreign policy aspect of it and making sure that the recommendations have a place within the UK's broader foreign policy, which can be a difficulty in coordinating these types of sanctions across multiple jurisdictions because foreign policy targets and goals may be slightly different depending on which government you're talking to. I'll also leave it at there for now. I'm sure we're going to carry on with the discussion later, but I'll pass it back to you.
Cool. Thank you, Natalie. Let's hear now from Mutasim of the Raoul Wallenberg Center for Human Rights about Canada's approach to corruption sanctions.
Thank you, Chloe, for beautiful introduction, and thank you all for attending our session. It is really an honor to be part of this esteemed panel. I hope we can engage in thoughtful discussion. Briefly, I want to highlight the importance of the Magnitsky sanctions and use of Magnitsky regime to target corrupt actors and human rights abusers. Magnitsky regime offers a new opportunity for governments to act alone to target corrupt actors and human rights abusers, and then rally other states to join their sanctions, their designations. Anchored by the legacy of Raoul Wallenberg and guidance of our professor Erwin Kotler, the Raoul Wallenberg Center has been the go-to organization in Canada to promote the utilization of the global Magnitsky regime against human rights abusers and corrupt actors. The ultimate goal, of course, is to hold perpetrators to account and to send a clear message that their behavior and their acts cannot be tolerated, and that they should be held to account. Over the last 5 years, our center has engaged in a series of meetings and testimonies in the Canadian Parliament, and as a result, it sort of resulted in acting the Canadian Magnitsky law, which is its official name is Justice for Victims of Corrupt Foreign Officials Act. The idea is to promote accountability for corrupt actors and also to bring justice to the victims. Not only that, but also as part of our work, we've led to the amendment of the Canadian Magnitsky regime to allow for assets repurposing to compensate victims of corrupt activities. Together with our partners sitting on a panel, and as a Canadian-based organization, we facilitate submissions in Canada, supporting other organizations who are interested in filing submissions in Canada, but also provide trainings to better utilize the Magnitsky regime to target human rights abusers and corrupt foreign actors. Unfortunately, as our report indicates, the Canadian government has not really or rarely used the Magnitsky Act to sanction corrupt actors, in part because Canada has been using different regimes. There are two regimes that Canada is using: Corruption of Foreign Public Officials Act, and then we have another act called Freezing Assets of Corrupt Foreign Officials Act. The difference between these two acts is that the Freezing of Assets of Corrupt Foreign Officials Act primarily allows Canada to act upon the request of a foreign state. This usually happens when there's political instability in a certain country, for example, like in what happened in Tunisia or in Egypt, or even in the case of Ukraine today. And so one of the things we were trying to argue through our report is to encourage the Canadian government to utilize the Magnitsky Act to sanction corrupt foreign actors. I think with that, I'm going to stop here and looking forward to further conversation.
Great. Thanks, Mutasim. And last but not least, Tika is going to talk to us a little bit about the EU and where it stands on adopting a Magnitsky-style law for corruption.
Thank you, Chloe, and good afternoon, everyone. as a last speaker, I have a task to make your attention to what I have to say. But I think it's also one of those jurisdictions where there is no adequate framework for corruption. So I'll try to explain what EU sanctions are and where we stand on anti-corruption sanctions. So there's always a first, and it's the first time I'm talking about sanctions half an hour before midnight, Brussels time. So bear with me if I don't make sense at some point, but I'll try my best. So EU is, together with the United States, one of the biggest users of sanctions in its common foreign security policy. It has 40 sanctions regimes, thematic and geographic. And it has used, especially in the last couple of years, extensively the sanctions as a foreign policy tool. However, there is a glaring omission where it doesn't have an adequate framework to target kleptocrats and oligarchs. It is not a novice to the anti-corruption work in sanctions. It has had in early 2010s, the so-called misappropriation of state funds, sanctions regimes against Tunisia, Egypt, and Ukraine. All these regimes were put in place following the revolutions in this country and in these three countries, and in a way as a support to the new governments in their efforts to fight corruption. And what transpired from those sanctions was that when EU adopts sanctions regimes and targets individuals, individuals are informed about their designation and about their right to appeal their designation. And European Court of Justice, located in Luxembourg, has gained increased competencies over the last 10 years to review the cases of designations and review the evidence that EU attaches to designations and whether there have been a proper judgment made and proportionate judgment for designations, given that it's a foreign policy instrument. And in all these three cases, in Tunisia, Egypt, and Ukraine, we call it these regimes collapsed. 99% of individuals got delisted because EU relied increasingly to the domestic investigations in these countries, and none of those have really materialized. And the court basically said there has been not proportional application of the law, and many of these individuals were delisted. The reason I'm mentioning this is that this experience is haunting EU a little bit now, currently when it's discussing anti-corruption sanctions. It has adopted global Magnitsky-style sanctions on human rights in 2020 following the UK, and it is utilizing it not to the extent that I would like it to, but it has a framework. But it lacks anti-corruption framework. It's adopted in 2020 because of the still litigations in the court. And at the moment, as you probably know, in September, European Commission President Ursula von der Leyen announced that EU will adopt such a regime, which is the first political statement from an EU official that EU commits to adopt such a regime, which brings us halfway there, that EU will have this regime sometime soon, but we are not quite there yet. There are ongoing discussions on legal issues and practical issues, and we have to have some strategic patience while they will come up around with these legal issues. It has also the Lebanon regime, which has a corruption specifically listing criteria, which is rather recent regime, adopted in July 2021. It is underutilized regime. It was adopted again within the framework of what EU is doing in Lebanon in the view of current crisis, socioeconomic crisis. And this is one of the ways we are kind of arguing with the European Union to use this regime to see how it will work, how they can do better and learn from the lessons that has happened after the misappropriation of state funds regimes. Now, Russia's war on Ukraine has brought the realization why EU needs anti-corruption sanctions more than before, because what we have seen is a designation of several dozens of oligarchs allegedly for their role in undermining territorial integrity of Ukraine. And now we already know 50 plus of these oligarchs are litigating at the European Court of Justice, arguing that there is not sufficient evidence to prove their role in this. And I think this will be another moment of truth for the EU to see that probably if there was an adequate framework to target these oligarchs for something they have really committed and have proper evidence, would have been in some instances much better tool to use. And probably there is a linkage why we have seen the announcement now. In terms of what we expect, this is one of the big priorities for us and many groups in Brussels and across Europe to EU to adopt this regime, not least because to work with like-minded partners, but also there are many glaring omissions. Like most recent one is Moldova designations of oligarchs from Moldova, which the United States has done. EU cannot follow this suit simply because it doesn't have an adequate framework, while Moldova received the candidate status in summer. So it would have been politically a very suitable moment for the EU to lend this support to the current Moldovan government. There are three things that we argue beyond legal issues that EU has to take into account, and disruption of the networks is one of those, which Amanda and others have talked about, and here the multilateralization is very, very important. Disrupting networks is not a completely new concept in sanctions. We always look at sanctions as behavioral change instrument. However, we have seen counterterrorism, cyber warfare, and chemical weapons sanctions a little bit designed with this in mind. They are not designed with the idea to change behavior of those criminal groups. So this is one of the arguments we are giving to our counterparts, that this could be one of the ways looking at it. The second important factor is a protection of the internal democratic institutions inside the European Union, because proceeds of ill-gotten assets have corrosive impact on the institutions inside the European Union, and here we can take the whole of the government approach while fighting corruption abroad and protecting institutions domestically. It's not a surprise that we see the proceeds of ill-gotten assets are kept in jurisdictions protected by rule of law and independent judiciary. So I think this component is very, very important. And last argument we are using is complementarity to anti-money laundering legislation. EU has relatively strong anti-money laundering legislation. I see people in the room who are better experts in this than me. It is not fully implemented. There is a problem and a gap in implementation of anti-money laundering legislation. And there is an issue of the nature of corruption. It's transnational, and the anti-money laundering legislation cannot always target transnational nature of corruption. And while anti-money laundering legislation targets proceeds of the corruption, anti-corruption sanctions could target the perpetrators, and this is where we see the main difference when it comes to accountability. And there are other issues, and I cannot underline enough how important for the EU, because of the role of the European Court of Justice, will be to adopt a regime that respects fundamental rights, that is proportionate. So these are some of the legal issues we use in our arguments. When it comes to civil society role, again, it comes to the role of the court has. You can only use open source material in all of its sanctions, no matter if it's corruption, human rights, or counterterrorism. It has to be open source for one main reason. When designated individuals go to the court, they have to see information which has formed the basis for their designation. And here comes obviously the role of civil society, the protections they have, and I'm happy to talk about that during the discussions. But the open source material is extremely important, and I think today we have a lot of this kind of information on corruption, and we can certainly recommend our jurisdiction to rely to a lot of investigations that have happened over the last years. I'll leave it there, and happy to answer questions.
Okay, thanks, Tika. Thanks, everybody. I'm going to start with one follow-up question for each panelist to kind of open the discussion, and then we're going to open it to the public, and we'll come around with the microphone, okay? So I'm going to begin with these questions, and then we'll open it up. Amanda, our recent report that you mentioned earlier that analyzes 5 years of Magnitsky sanctions found that the U.S. has issued drastically more corruption-based sanctions than any other jurisdiction, 285 compared to 12 and 27 in Canada and the U.K., respectively. Why is this? Why do we have this discrepancy in corruption sanctions? And more importantly, how can civil society play a role in trying to bridge that gap?
Sure. Thank you, Chloe. So I think part of the reason why the U.S. has such a large number of corruption sanctions, by some measures about tenfold the size of some of the other jurisdictions, is one, we're the oldest program. So we were first out the gate. We've had a bit more time the U.S. government's had a bit more time to get rolling on that. Two, I think both the previous administration and the current administration have, in different ways, made corruption in different parts of the world a priority. I know that's increasingly been a priority for the Biden administration, and we've seen some of the largest corruption sanctions designations come out, especially last year. There's a huge focus on anti-corruption sanctions. So I think those are certainly policy signals to the broader community of the priorities of these different administrations. I think really a lot of it does come down to that network approach for sanctions. Again, like I said earlier, there's been about 40 or so incidents or situations of corruption that have netted around 300 designations. So it is purely the size of the number of entities, the number of associates that they're going after and including in public lists of sanctions for corruption. And so I think that is part of the reason why the numbers are so large. If you look and drill down like a little bit more to see how evenly are they using these between corruption and the human rights side of the sanctions, there's pretty good parity between the two. It's not 100% like one human rights case, one corruption case, one human rights case, one corruption case, but there's a decent balance there. It's just the size of the networks that I think are quite extensive. And again, I think civil society has played a role in helping bring forward some of the largest cases that we've seen addressed to date. And so the role that we play at Human Rights First is being able to work with civil society groups one-on-one to offer trainings in the programs to help them better understand the legal frameworks, to provide assistance to groups who are drafting and preparing detailed recommendation files that lay out not only with specifics what abuses occurred, but also who should be pointed to as most responsible for those abuses, who are their associates, what entities or companies do they own or control, kind of helping them understand the full scope and power of these sanctions tools, and you'd be able to help NGOs hone and develop as well documented and well-sourced information as possible. And then at Human Rights First, we have secure channels set up with the Treasury Department, State Department to be able to provide that information to them and to connect NGOs with the investigators and with the folks who are going to be reviewing the files and going to be potentially, hopefully, acting on them. So that's a model that the Global Magnitsky Act, the original genesis of this whole program, invited in a sense. The act itself stipulated that Treasury and State needed to be consulting with and taking in information from credible NGOs when they're making decisions on how to use these sanctions tools. So our predecessors at Human Rights First kind of took that and ran with it and built up the relationships with the various players at the Office of Foreign Assets Control, the Treasury Department, at various bureaus in the State Department. We have good working relationships with them, and I can say they stress to us constantly that they put such incredible value on the information that civil society brings forward, because they are the eyes and ears on the ground and have information that people in offices here in DC can't as easily access. So our goal is to help NGOs bridge that gap and bring that information to the U.S. government to be able to hopefully act on.
Perfect. Thanks, Amanda. Natalie, I want to go back to what you were mentioning earlier, which is that the UK has a bit of a different definition for what they consider serious corruption to be. Could you elaborate on that a little bit? And then also along those lines, how can NGOs navigate these mechanisms? Obviously, there's a million moving pieces and a million different mechanisms. So how do they navigate that across multiple jurisdictions when the legal definition for the behavior and policy considerations change depending on jurisdiction?
Yeah, thank you. So I think this is one of the key challenges, actually, of using these mechanisms. Whilst they all kind of have the same aim, each jurisdiction goes about it in a slightly different way. I'm not sure if that's still working. So under the UK regulations, serious corruption is very restricted. It's restricted to only misappropriation of property and to bribery. So compared to the US approach, which takes a slightly more expansive approach of what can actually constitute corruption, under the UK regulations, it's actually quite set in stone as to what the UK government will consider sanctioning for corrupt activity. So that's something that NGOs and civil society need to take into consideration when you are preparing recommendations and submissions with the intention of submitting those recommendations to multiple governments. that's part of where our coalition and what we do comes into play. Obviously, it's a global coalition that covers all these different jurisdictions, and so we have a very good knowledge of how our individual systems work. I think in order to, first of all, having that sort of broader understanding of corruption is quite an important one, and one that we've stressed to the UK government in various different ways. Their approach of sort of defining corruption in such a restricted way is one way of doing it, but obviously then you are losing out on quite a lot of different types of corruption. For example, the sort of more state capture or patronage awards type corruption that the US has managed to capture in some of its sanctioning activity. So that might be a reason why the UK is unable to act in certain situations because the legislation prevents it from doing so. I think it's also important to remember that the legal standards that jurisdictions apply when putting in sanctions designations can also be slightly different, which Tika's touched a bit upon. Obviously, governments are worried about these designations being challenged in court, and so the type of information that they'll be relying on might be slightly different depending on which jurisdiction you're at. We, like the EU, the UK relies solely on open source information in terms of when it decides to put in designations. Part of that is to protect the confidentiality of NGOs submitting information. The approach is that open source information is a slightly safer way to go about it because it's already publicly available, and therefore the security risks to people providing that information is less. However, that does lessen some of the information that can be given to the government and which the government can rely upon, and isn't necessarily the situation in other jurisdictions who can rely on more confidential or private information. So some of these are just sort of some of the challenges that NGOs can have when trying to submit recommendations to multiple jurisdictions at the same time. Again, no specifically easy way to navigate that. Our coalition does try and use submissions where, say, they've been submitted to the US first, we'll adapt them for UK purposes and then adapt them to the and send them to the UK. But I think when putting together these types of recommendations and identifying targets, that's an important thing to keep in mind, that although these Magnitsky regulations can target corruption in general, how states define corruption and how corruption is actually understood in different parts of the world is a really, really key consideration in deciding whether or not you should be using these types of tools.
Thanks, Natalie. And to clarify it too, our coalition, its role is to kind of help take that burden off of civil society, to help them understand the way that these different mechanisms work and the way that the jurisdictions differ and how the laws are different. And that's why we have jurisdictional chairs and we have regional chairs that work to specialize on the regions and work with the different jurisdictions to convert cases. So while all this information is extremely overwhelming, there are tools that help you approach these mechanisms in a way that is more digestible. And that's kind of the role that we play here. Mutasim, I have a question for you. Canada has issued very few corruption sanctions, especially compared to the other jurisdictions. Could you please speak to what different geopolitical interests might play a role in the decisions to impose targeted human rights and anti-corruption sanctions? And beyond that, in your opinion, do these considerations invite or obstruct possibilities for future multilateralization?
Thank you, Chloe, for the question. And as I indicated in my introductory remarks, despite the fact that the Canadian Magnitsky law is named Justice for Victims of Corrupt Foreign Officials Act, Canada has rarely used the act to sanction corrupt actors. And I think primarily because Canada is using other regimes, as I mentioned earlier. I think Canada used freezing assets of corrupt foreign officials act quite extensively in three main occasions: in Tunisia during the after the Tunisian Revolution in 2011, in Egypt as well, and in Ukraine. And so that's, I think, part of the reason why we see a small number of corruption cases under the Canadian Magnitsky-style regime. And just to give you a little more information about the Canadian Magnitsky regime, there are primarily two acts, right? The Justice for Victims of Corrupt Foreign Officials Act, which allows for sanctions against human rights abusers and corrupt foreign actors and their enablers. Plus, we have the Special Economic Measures Act, also sanctioned for the same human rights abuses and corrupt foreign actors. The main difference between the two is that Justice for Victims of Corruption and Officials Act allows the Canadian government to unilaterally, sanction individuals, not entities, whereas the Special Economic Measures Act allows the Canadian government to sanction individuals, entities, and states. With respect to geopolitical, concerns, I think again, as Tika mentioned earlier. Sanctions are, political acts. Basically, they're being used by governments to change behavior, but also to disrupt the activities of corrupt foreign actors. And therefore, always the political interest will be considered there. And so, one way to, to go about it is, to demonstrate to the governments that sanctioning, even though the governments in some cases might be allies, that sanctioning individuals or entities should be in the interest of the partnership and the relationship between the countries, right? I think that's the main argument that we should use, and that's part of the reason why usually when we file for submissions, we demonstrate in the section of national interest that it is in the respective government's interest to sanction, these individuals or entities. And so I think that's what I can say about the geopolitical interest. I forget the last part of the question.
Do you consider these geopolitical interests and all the different factors at play an obstruction, or do they obstruct the possibility of multilateralization, or are there ways in which they invite that?
I think in many cases, when, let's say, for example, in the case of Canada usually acts multilaterally, especially with the US, UK, and EU. And when, in cases where Canada considers, a country as, so this is not in our political interest to sanction individuals or entities in such country, probably that would be the same in other jurisdictions as well. And I think, yes, this, in a way, it obstructs, sanctions designations in these situations. But again, I think I'll just go back again to the point I mentioned earlier about the demonstrating that it should be in the interest of the relationships between our jurisdictions that use Global Magnitsky Act to sanction individuals and entities for corruption activities and human rights abuses, to sanction individuals and bad guys, right? That's what we need to demonstrate all the time. Thanks.
Yeah, I agree. I think a key takeaway from that is the importance of understanding how many different factors are at play in the issuance of these sanctions. I think that that's something that everyone's touching on here, but these are political decisions by the governments at the end of the day. And so, in the US, it has to go through state, treasury, embassies, things like that in order to get approval. Canada, you've got the ministers that need to approve. The EU has 27 member states that need to approve. So you can see that all of these there's a lot of consequences to these sanctions, and as such, the back process of deciding what is actually going to be issued is always up for debate, and as such, as civil society, a key role that we can play is making an argument for the government as to why should they do this, what will the impact be, and how can we ensure that the issuance of this sanction is less of a risk and more of a benefit for the sanctioning government. So that's just something to pull out of what Mutasim has just said too. And then one last question for Tika, and then we're going to open it up to you guys for the last 30 minutes. Tika, following the announcement of the president of the EU's Commission in September 2022 about their commitment to adopt an anti-corruption sanctions regime, in your view, what are the next steps to ensure that the EU actually does that? And how can it best avoid the legal vulnerabilities and ensure a robust and actionable framework?
Yeah, $1 million question. So I would start where Mutasim left and what you said, that the anti-corruption sanctions. I don't think that's working. No. Anti-corruption sanctions are prone to the political bias and inconsistent application, and that's why there's a lot of attention to be paid of how it is shaped legally in the EU, like in every other jurisdiction, but because of its history of the anti-corruption sanctions being on a legally on a vulnerable basis. Here, I think three things I would outline. International standards are very important for any EU law. And downside of it is that when we talk about human rights, for example, there are many international standards. There are whole conventions at the UN level and Council of Europe level. We don't have so many on corruption, and I think this is where EU is struggling. There is a UN Convention Against Corruption where they are looking mostly at what UK relied primarily, and I think this will be one of the few international conventions or standards they are going to rely because it's important for the application of the EU law. The second is definitions, and here is a little bit of K25. The broader the definition is, the easier it is for the EU Council to defend because it's a broad definition and you can put whatever there. It's a bit problematic on corruption, however. For example, on human rights sanctions, if you talk about gross human rights violations, it's so broad that any type of violation can fall into that. The narrower the scope is, let's say, a bribery, you need to be very, very specific that bribery and not some grand corruption. So it's a balance you will need to strike, how to put definitions, what scope to put in there, and how to make sure it's a regime that is aligned with other jurisdictions and it's not something completely different. Another component will be the role of civil society and expertise within the Council. As Chloe mentioned, there are 27 member states that take decisions on sanctions and on any foreign policy issues. There is no opportunity to do opt-out or other kind of votes. And there is, at the moment in the Council, which deliberates on these issues, no expert group on corruption in general. I'm not even talking about corruption sanctions, corruption. And one of the things down the line, it's a little bit high ask for the EU, is that we are arguing that it needs such an expert group overall for corruption, also internal, external, because it will make it easier when you have experts, 27 experts in the group, to come up with designations, the criteria to engage with civil society in a much more meaningful way. And the last bit is about civil society. Now, unlike the US law and UK law, EU law doesn't provide specific reference to civil society, so there is no such thing in the EU legislation, in none of the legislations, I would say. Having said that, there is a really open door policy from the EU, and we do have similar open channels, confidential way of transferring information. So I think even though there is no official reference in the law, we do have this open access to on different levels with the member states or with the External Action Service. So it has to become much more open, and especially on such a contentious issue such as corruption sanctions, there will be much more bigger need and appetite from the European Union to work with civil society because they have to rely on the investigations with journalists, investigative journalists, civil society organizations from the ground. So these are the legal steps. On the political side, now we have an announcement. In order this to become a reality, there is a need for the High Representative of the European Union to give a mandate to the Council to start official negotiations. There is no mandate yet because there are still discussions around technicalities, all of the issues I just mentioned. Once there is the mandate, then I can be quite certain we will arrive there within a couple of months, but there is no mandate at the moment, and all the work is directed towards that EU to have an official mandate to work on this regime.
Well, let's hope we get to that mandate soon. Okay, so now we're going to open it up to the audience. Alex is going to take a microphone. Please state your name, your organization. Hold on. Your name, your organization, where you're from, and wait for the microphone before you ask your question so that people on the live stream can hear us. Alex, let's start here, please.
Thank you so much. This is a very excellent section. My name is Anderson D. Merman. I'm from Liberia, and I'm head of the local chapter of Transparency International in Liberia. The institution is called the Center for Transparency and Accountability in Liberia. I'm happy to be here, and thank you so much for the deliberations. There are a few questions I have. Number one, I need clarity on what do you mean by the numbers in terms of the use of the sanction. Is it when group of individuals are sanctioned together, or when you disaggregate that sanctioning to say, okay, the U.S. government sanctioned maybe 5 Liberian officials at once, and each of them constitute the sanctioning. That's something I'd like to know, whether group sanction is one, or you look at individuals and then say, okay, yeah, even though you are 5 at a time, but then you are 1, you are 2, you are 3, is something I need clarity on. Then the second point is, how do you engage with, or do you intend to partner with civil society organizations in countries where these sanctioned individuals and networks are situated? Like Liberia, for example, we've had a number of public officials sanctioned for different reasons. The most recent ones are 3 high-ranking officials. The person who manages or used to manage the office of the presidency, we call it the Minister of State for Presidential Affairs. He was sanctioned along with 2 others. The person responsible for prosecution, we call him Solicitor General, and the person managing the port, the National Port Authority. So, yeah, how do you partner with organizations in Liberia like mine in doing this work? Then the other one is, in a more direct way, what are your challenges or your threats in doing this work? It's something that I'd like to know so that I learn from it, and maybe others here can benefit from the information you share as they engage with the work. Then I think the last point, since others will need time to speak, is UK is sanctioning, the US is sanctioning, and other people might be doing it. Is there any coordination between the UK government and the US government? So if I'm sanctioned for maybe drugs dealing or for corruption in Liberia, and the US government sanctions me and the UK government sanctions me, is there any coordination there in terms of how to make things work? And my last recommendation to you would be, if you aren't doing it, to follow up or monitor the impact of the sanctions in the countries where these individuals are being sanctioned. So the officials that have been sanctioned in Liberia, maybe to do a bit of research, it might help, to get information out there about the effectiveness of the Magnitsky Act. What has happened to those that have been sanctioned in Liberia? Have they resigned? Have they been prosecuted? Are they being denied public offices? Have citizens opted against voting them to power because of that? Yeah, that's something that I'd like to recommend to you. But, we'll talk more after this so that we engage the rest of. Thank you.
Yeah, thank you. Okay, we're going to really quickly respond to those. I'll take the question about partnership and challenges, then Amanda, pass it to you for clarity in numbers and kind of coordination across jurisdictions. Partnership with civil society is what we do, period. So if you have a civil society organization or you work for a nonprofit organization that is interested in learning about these mechanisms in greater detail, or that wants to document and submit a case to any of our jurisdictions or all of our jurisdictions, you can come to us and we can train you on that, and we can help you build the case, edit, revise the case, and submit it securely to the various governments. So we are probably who you want to come to. We serve as the clearinghouses for each of the jurisdictions and for given regions. So that is what we do. Challenges in this work, I can speak to my own experience. I represent Latin America on the coalition. My partners don't have access to most of the resources because they don't speak English. So that's like a first challenge. There's a lot of language challenges. There's a lot of access to information challenges. There's a lot of organizations like ours that are doing this work to try to educate civil society organizations on these things and try to filter information down because we recognize these barriers. I think another significant challenge is what you mentioned, the coordination across jurisdictions. To date, I can speak for my partners. For example, we documented a case in Nicaragua that resulted in public sanctions. We submitted it. It got sanctions in the US. We then had to convert it to the Canadian legislation. That takes time. Submit it. It got a sanction. We then had to convert it to the UK. These kind of things take time. And so what we're hoping to see, and Amanda can pick this up when she talks about the coordination or lack of coordination between governments, is better accountability for that from the government so that the civil society groups that are already putting in the work to do this documentation, to acquire the evidence, have less of a burden on them to do the kind of conversion from cases to different jurisdictions and things like that. So that's a concise answer. Amanda, a minute to talk about the clarity of numbers and the coordination challenges for the jurisdictions.
Sure, thank you. So on the numbers question, everything that we said is actual individual people, individual entities. So it's not like the 3 Liberia sanctions that you mentioned. That's not one. That's 3 different individuals per our numbers. So that gives you a bit of a scope of what we're talking about here. On the the coordination between governments, we have heard, I think, repeatedly from the different jurisdictions that we're in contact with that they are sharing information, that they are trying to coordinate with each other. We have seen on occasion where they'll do joint announcements for sanctions, or maybe one jurisdiction will sanction a particular individual, and then another will follow, a couple months later, a year later, et cetera. It's a goal of ours to continue to press jurisdictions to be doing that multilateral work more, because again, it increases the potential impact for these sanctions. You potentially freeze more assets, you potentially block people from traveling to more jurisdictions, you block them from being able to engage in business relations or transactions with individuals in more places. And so we're doing our part as civil society to help governments ensure that they are all getting the same information as simultaneously as possible. And as Chloe mentioned, this is a process that I think in the past has taken a really long time. But as we've built up and further our relationships with governments, I think we are now looking to try to more quickly streamline that information sharing when requested by civil society, to ensure that if a case of recommendation is submitted to the U.S., it's able to be shared quickly with the UK and the EU and Canada as is relevant. And we can tell all of the jurisdictions, we know you all have this information now, please work together, and we would like to see some action and results from that.
Thank you. Okay, next question.
There was one on the impact,
Yeah.
assessing the impact of the sanctions in the different
We
countries.
do that.
Something that
We do follow up for that, especially the civil society organizations that we work with do follow up for that. Even just today, we met with some government officials, and they said it's very important for them that civil society share that information with them, because the whole point of these sanctions are for them to be preventative and not punitive. So they're trying to change behavior. And as such, the information that is shared, the impact that it's had, is very important. We try to do our part. Another challenge that we face is bandwidth, obviously, as NGOs and CSOs across the world do. And so we do our best to follow up when and if you do see circumvention of sanctions. For example, in Nicaragua, the mining industry was sanctioned. The government recently issued a whole new decree saying we're going to create a new entity that can do mining for us. We followed up with the U.S. government and said, hey, this happened. We see them trying to go around these sanctions. If you want to actually have an impact on the sanctions, know that this is happening. And they came out with a new executive order to say anyone in gold mining can be sanctioned in Nicaragua. So things like that, you have to kind of follow up and provide accountability with the governments. Obviously, there's a bandwidth concern, but to the best of our ability, we do, because impact is what matters in these mechanisms. Okay, next question. How about here, Alex? And then we'll go to the back of the room. I see you. Sorry.
Hello, my name is Ilya Shumanov. I'm from Transparency Russia, Executive Director. Yeah, you are talking about the changing behavior and the policy changing as a, let's say, approach of the sanctions, the reason of the sanctions. Yeah, and now there is a fun fact that the number of the Russian governments who are under the sanctions, it's okay, but the number of them, they are not under the and they're trying to be sanctioned by the number of your governments because it's unpatriotic for them being not sanctioned by the governments, foreign governments. I suppose that there is a stick and carrot approach. There is a stick, you're sanctioned, and what is a carrot? Carrot is lifting sanctions. Can you explain the protocol of being unsanctioned, lifting sanction, for those who decide to comply with sanction and who decide to, let's say, behavior change and who show that he or she decided to change their behavior? Yeah, just because it looks like you're doing some things related to the imposing sanctions. But could you advocate for sanction lifting, for example, for those who decide to comply, okay?
Okay, thank you. Alex, let's take one more question before we advance.
Sure. There's someone in the back. Hi, thank you for the presentation. My name is Raoul. I'm from Freedom for Eurasia organization. And what I'm interested in is actually the sanctions evasion issue. Because, I mean, it's the next thing that's on the corrupt leaders' mind. If you have a sanctions, they'll try to find a way to get around it. I mean, whether it's Magnitsky or sanctions against Russia, and there's information already floating around that Russia is using, like the other republics of former Soviet Union, like Kazakhstan, to circumvent sanctions. So what's your take on that? I would appreciate if you can.
Sure, no problem. Okay, about 2 or 3 minutes to respond to that so we can get some more questions. Who wants to tackle those, or at least one of them? Okay.
I'll start with an evasion bit. So it is indeed, especially in the current context, talked a lot. There is a lot of rumor out there, and jurisdictions are aware, and in particular EU jurisdiction, where sanctions are adopted at the European level and implemented on the national level by 27 different jurisdictions. Obviously, we have a big problem there. So the Russia sanctions has brought a lot of discussions how to harmonize that, how to harmonize penalties. For example, sanctions evasion is criminalized in 14 out of 28 member states. It's only administrative offense in the rest of the EU member states. So now the legislative proposals have advanced to make EU sanctions evasion EU crime, to harmonize legislation. This is only legislation, right? We can have very good legislation, but very poor implementation. So implementation is another hurdle for the EU. Another thing is when we talk about evasion, we really need to come with hard facts, which is very, very difficult because it's called evasion because it's done behind some closed doors. So EU in March has launched a whistleblower protection platform. It's a website. I'm happy to give you the link afterwards to all of you. I don't have it now on top of my head, where you can, anybody who has any information about sanctions evasion of any EU sanctions violations can submit information anonymously on encrypted inbox or on your own behalf, and they follow up with the respective either EU member states but also with G7 partners. So in recent meetings, I asked them how many submissions they received between March and now. So it's a very short period. They received 515 submissions, out of which only 1/4 are worthy of investigation. Some of them, they say, just a steam blowing off the steam by some people submitting some. They're angry because something is happening. So it's very important. The bottom line is here that when we talk about evasion, we have facts right, we have investigated, and we have something that we can give to jurisdiction to follow up. On the rollback of sanctions and ramp-offs, it's a very difficult one also. On the EU side, one thing I can say, it requires a lot of work to find out where they are. They are typically not in council regulations which lists people, but a little bit more. I mean, this is something we raise with EU a lot, so that they have to centralize these issues much better. For example, before sanctions are adopted, it is not adopted out of the blue. There are council conclusions, 1, 2, 3, or sometimes 10 council conclusions, which lists what are the issues. Like I take Belarus as an example, 2020. There are a number of council conclusions which says what is it that EU is asking Belarus to do. Free and fair elections, international monitoring mission, protection of human rights. So if these conditions are met, the sanctions will be lifted. But the problem is this is not put in one place. So this is a problem you are raising. It's a very valid question. It has to be done much better. But it is not that it's not there. It is there. In our capacity, I think it's a bit hard to advocate for lifting of sanctions. What we can do is to make it clearer what are the conditions based on what sanctions can be lifted. I mean, we have such a bad example, for example, Uzbekistan sanctions in post-Andijan in 2005. It was shortest lived sanctions, lifted in 2009. Out of 9 conditions EU imposed, only 1 was met. And we figured out those conditions through reading council conclusions. Only 1 condition was met, and all the sanctions were lifted. So I think it's a little bit of a mixed bag talking about that, but something that can be done much better than it is done to date.
Okay, let's go on to next questions. Back here, please, Alex.
Hi there, Eva Khan with C4ADS. Thank you all so much for your remarks. I was struck by how the challenges of sanctioning corrupt officials in Egypt and Tunisia after their transitions shaped both the Canadian and EU approach to corruption sanctions, as they have also shaped the approaches to asset freezes, mutual legal assistance, and other legal measures over the last 10 years. I'm wondering, for anyone on the panel, how can the international community think more imaginatively about supporting transitions with sanctions? Or are GLOMAG sanctions not the correct tool to be using here? And do we need a legal framework tailored to supporting governments in transition? Thank you.
Good question. Thank you. We'll take another one. Alex, over here.
Yeah, thank you. I'm Joaquim Stassar from Transparency International Brazil. I work mostly on environmental crimes in Brazil, and I was wondering how those targeted sanctions can be mobilized to hold the perpetrators of forest crimes in Brazil accountable. I know that it may sound out of the scope of targeted sanction, but there are very clear evidence that corruption is making environmental crimes possible, and also that it's very much related to human rights, as in Brazil over the last decades over 300 environmental and land defenders were killed. So I was wondering if you can comment a bit on that, how those targeted sanctions can be mobilized on that, and also what can be a strategy for civil society to advocate for better consideration of environmental crimes. Thank you.
Okay, great. Who wants to tackle the first question about Egypt, Tunisia, imaginative, creative sanctions tools for governments in transition?
Great. Thank you for the question. I think that's really not an easy question. But first, I just want to say that, using targeted sanctions can actually contribute to democratic transitions. And this is part of the reason why Canada enacted Freezing Assets of Corrupt Foreign Officials Act, right? As I mentioned, that act can only operate when a foreign state, such as Egypt, right, requests the Canadian government to impose sanctions against corrupt individuals, while they were in power. And I think that's, I think that's really an important tool to help democratic transitions. And I think the other part of it is targeted sanctions, as it was earlier said, as it can be used as a stick and carrot, right? Like, for instance, we can, if you do not, or if you undermine the democratic process in X country, and this is actually being used in the case of Sudan during the democratic transition in 2019, 2021, and primarily the U.S. sort of threatened the Sudanese leaders that if you do not, or if you undermine the democratic transition in the country, then we will consider sanction those who involved in the undermining of democratic process. On the flip side, though, if you promote democratic transition, then we can support you and all of that. And so I think targeted sanctions can be used to support the democratic transitions in many places. I just want to touch quickly on the question about human rights in Brazil and the issue of forests, undermining environmental issues and all of that. And I think, again, at least in the Canadian context, our sanctions regime pretty flexible to operate in such situations, right? Like, the one thing that you just, or two things you have to meet is that if the act, constitute gross violation of internationally recognized human rights, right? This is number one. Or if we're speaking of corruption, if the act constitutes a significant corruption as defined earlier by Natalie. And so, yes, in both situations, in Brazil, that, target sanctions can operate. And I think the major question that you face there is whether you're able to demonstrate that sanctioning individuals in Brazil is in the Canadians' national interest, right? And again, this comes back to the question of, if this is like a good policy strategy to work to sanction individuals in Brazil. So I'll stop there.
Okay, so I'll complement both of those answers. Regarding transitions, something interesting that we haven't talked about but that is really relevant is that when you hear the term sanction, you think of it as something that's meant to like be in contrast to a government or kind of in opposition, and that's not really the case. Oftentimes we see governments issue sanctions in support of an issue to be more transparent. So for example, last year, we saw the U.S. government sanction a governor in Mexico for orchestrating the torture of a journalist. And that sanction was issued at the same time that the Mexican government was moving nationally to hold that person accountable. So it was the U.S. saying, we support this. Like, we support your insistence on transparency. And as such, it can be used more creatively in solidarity with governments that are stepping into transition and into power as a way of supporting them and trying to clear out the corruption that might exist under them from previous administrations. So that's one answer. Regarding Brazil, we're working on it. We have some cases that we're working on with that. Something that's probably useful to think about is that there are two prongs. There's corruption and there's human rights violations. And so while land right protection is not a sanctionable act in and of itself, there are things under both of those prongs that are sanctionable that pertain to land rights. So for example, corruption that is misappropriation of land is sanctionable. So if a government is not, for example, consulting indigenous peoples on that land, or it is illegally taking that land and selling it without engaging with those persons who have rights to that land, that can be corruption. That can be sanctionable. Same thing with environmental defenders who are murdered by corrupt international crime organizations or by state actors. You can get at state actors and non-actors in the same case if you're able to prove that human rights violation, that extrajudicial execution, that torture, that arbitrary detention is connected to these kind of things. So land rights itself is not a sanctionable act, but there's so many crimes that exist around the environmental protectors that are sanctionable. And as such, it's completely doable. Not only that, but it has been stated as a policy priority by various of our governments that they want to sanction for environmental crimes. And so there are ways to do that with just a different kind of focus on what the sanctionable act is, and then you frame the context of the case and what you present around it being of policy interest to these governments. Amanda?
Just really briefly on the topic that we've been talking about related to Brazil, I think one of the other gaps that our report highlighted on the human rights side is we looked at what types of victims are and are not being recognized through the sanctions process, and particularly drilled down to look at specific certain marginalized victims groups. And kind of tangential to this but related is the fact that there have been almost no sanctions related to abuses against indigenous peoples. And that is a huge oversight and something that we're trying to work with governments to encourage them to be more proactive and to show solidarity and support for indigenous peoples, land rights defenders who are on the front lines and often face much higher rates of abuse and violence and murder. And so if that is also something that you're seeing in part of your documentation related to these types of issues, that's an policy area that we're, I think, actively trying to push governments on to be more proactive and to recognize that certain marginalized groups are being severely impacted and not recognized yet through these sanctions programs.
Yeah, and so while you need to have a sanctionable concrete act, you can also talk about the broader implications. You could point to Bolsonaro's administration and it pulling away all of the protections that exist for land rights defenders and indigenous persons as part of the general framing of why this is an action that the U.S. government or the Canadian government or the UK would want to take. So you can bake all of that into one case submission. Let's take a couple more questions. Okay, right here, and then we'll take another one in the back.
Hello? Hello? Do you hear me? Okay. My name is Natalie Lucas. I'm from Université de Sherbrooke. It's in Canada, Quebec. Okay. And I have a couple of follow-ups for the things that's been discussed, and also one question. So basically, I have a short comment on geopolitical aspects. I found that interesting in the discussion, and it reminded me of one example from the past. It's not on anti-corruption sanctions, but sanctions per se. Sometimes, if there is a lot of pressure from from civil society, the geopolitical goals can be overcome. For example, there were sanctions against Brazil and Argentina, if I'm not mistaken, in the 70s, and the U.S. Administration has imposed those sanctions on the countries that were their partners, basically strategic partners in the times of Cold War. Just because there was a lot of pressure through the Congress due to extensive human rights violations. So that's an example how civil society pressure can overcome any geopolitical constraints. Then about multilateralization of sanctions, I was wondering if you work with some of your colleagues in other jurisdictions, like, for example, I know that Baltic states have also Magnitsky legislation. Australia is coming close to that, and even Ukraine considers some kind of Magnitsky type legislation. And I understand that that might be not as effective as coming from global economies with a lot of power like Canada or United States or EU, but still it can be also good in terms of naming and shaming and also international solidarity. And to finish with that, I would like to pose the questions, and whoever wants are welcome to respond. What do you think about universal obligation to fight corruption? Like something, there's been a lot of discussion currently about the possibility of establishing international anti-corruption code, or I think it's a little bit too far to think, but there is international panel, international criminal court, and there is a lot of controversy around that. But if corruption is perceived as a violation of obligations, universal obligations like fundamental human rights, like obligations of humanitarian law, like genocide, it could be a good framework for any further work for civil society. And I think a lot of pressure is needed from bottom up to come to this result. So I would like to hear your comments on that.
Okay, perfect. Thank you. We only have like 5 more minutes, so I want to take a couple more questions right here.
Hi, my name is Lorena. I'm with Pucminas in Brazil. And I have a question about what are the biggest impediments for the establishment of international standards to define and fight corruption by the UN, for example, or another global actor. And that could bridge the gaps between states and promote multilateralism. And similarly to what happened in the South African apartheid, and of course the work of NGOs was completely remarkable. And then the states could finally articulate the sanctions regime that ultimately led to the end of the apartheid. And I was wondering what are the actions that, actually, what are the biggest impediments for that to happen and endorse a global fight for corruption?
Thank you. Okay, one more question, way in the back.
Hi, everyone. My name's Clancy. I'm the CEO of Transparency International Australia. Australia has recently legislated and introduced Magnitsky legislation as of December last year. So far, Australia has used Magnitsky to sanction many Russian entities and individuals, which is good. But I'm wanting some advice from the panel. To date, no sanctions have been placed on any Myanmar nationals or also members of the Cambodian junta, who we know have been profiting from the proceeds of corruption and human rights abuses and often using Australia as a safe haven and destination for their dirty money. Clearly, I would argue that it's in Australia's interest to have strong democratic systems of governance in our region, but for some reason the government is reluctant to introduce or use the legislation to sanction certain individuals.
Okay, great. Let's start with the first questions about overcoming geopolitical goals, multilateralization, the recognition of, this kind of goes at the Australia one as well, but the recognition that other jurisdictions also have these mechanisms and how to go about engaging with them. Who would like to take that on? Natalie? Okay.
Happy to have a bit of a go at that one. I think those are all really excellent points. I think the point on sort of international standards and how do we make sure that these obligations are sort of seen throughout, and the point about the International Anti-Corruption Court, I think that kind of goes to that point that corruption can be seen quite differently by different jurisdictions and also by the sort of people that would be being sanctioned under these types of jurisdictions. And so part of our work as civil society is to sort of make that clear to government. So in the case of the UK, where we have quite a restricted definition of corruption, it's making sure that that definition is used as innovatively as possible to cover as many types of corruption as possible, at the same time as advocating for a more expansive and wider and more nuanced understanding of what corruption can actually entail. So I think that's really important because obviously governments are taking quite different approaches to what types of corruption they're focusing on and how they're defining that corruption. And so I think that's a really important point that needs to be sort of acknowledged by all different types of jurisdictions on how they tackle corruption. The other point I think was the sort of question of the intersection with human rights, which has been raised by I think a couple of the questions, and your point about apartheid. I think the key thing to remember with Magnitsky sanctions is that they are quite different from a sort of countrywide sanctioning regime that was potentially used against South Africa. These are targeted against specific individuals. So some of these geopolitical concerns that come in are more easily battered away because of the individual nature of the targeted sanctions that you're asking for. You're not asking for sanctions against an entire country, you're asking for sanctions against an individual. And that is a really important distinction to be making to governments in terms of foreign policy because it's not intended to be a punishment against a countrywide state. So in terms of the intersection with human rights, I think that's also an important point to keep in mind with Magnitsky legislation. As we discussed, the legislation itself comes from Sergei Magnitsky, who uncovered a corrupt scheme, and then that led to his human rights being violated and his eventual murder. And so it's important for governments to recognize that corruption can often be the root cause of many issues within different societies. And this sort of leads into some of the other points that were being made about societies in transition, where corruption can sort of lead to that sort of political instability that we've seen in Russia, or further human rights abuses, which maybe took place in other types of countries. And that sometimes tackling corruption as the root cause of that may help prevent future human rights abuses in the future. So, I think that's kind of, I'll leave it there because I know we're running out of time. But.
Yeah, great. Okay, and then about especially the Australian Magnitsky law, Myanmar, Cambodia, what can they do to advocate in front of the Australian government to issue sanctions against these actors?
And I think this falls into the multilateralization efforts. Our center actually involved extensively in testimonies and meetings with Australian officials and Japan, Taiwan, all of these places to maximize the utilization of the Magnitsky Act. And I think, of course, this requires engagement of civil society organizations in respective countries, as well as, some, good application of Magnitsky in jurisdictions like the US, Canada, EU, and UK. And I think if we can demonstrate that the Magnitsky regime is very effective in terms of changing behavior or disrupting the activities of corrupt actors, I think that would make a good case, to adopt Magnitsky style in Australia and other places.
Sure. I mean, I don't have a silver bullet answer, I guess, to the question about the Myanmar and sanctions in Australia. I think Australia obviously is one of the newest programs or newest countries to join kind of the Magnitsky community. And, I think one of the key things for civil society to keep in mind is to continue to build those relationships with whatever ministries and individual advocates within Parliament or other bodies that can be advocates and champions internally for the system. I think each jurisdiction's kind of figuring out where its lever points are and its push and pull, and that's something that kind of changes over time. So being able to map that out and be talking very comprehensively to the actors that may be involved in the decision-making process, and as well talking to the public to the extent possible, because building public pressure for these types of campaigns can sometimes be quite effective, and finding those key champions within government to be able to move things forward can be incredibly helpful. There's some jurisdictions, some countries in the U.S. where we know there's very low odds that the U.S. government is going to sanction individuals from that country. But there are moments where things happen that can crack through that sort of that hesitancy or that reluctance. I'll point to, at least on the human rights side, the case of Jamal Khashoggi and his killing, and the fact that the U.S. government then sanctioned 19 Saudis for his murder. And if you had asked anybody if the U.S. government was going to sanction some Saudis, a month before that happened, the answer would probably be like, that doesn't seem very likely. So there are sometimes moments that arise where the thing that was impossible before became possible. So our job as civil society advocates is to keep pushing on the impossible until it becomes possible.
Okay, thanks, Amanda. Thanks, everybody. We could sit here for hours, but we actually have to close now because we're already over time. Thank you all for being here. I know you're exhausted. You've traveled. It's been a long day, but we really appreciate your time. We'll be here if you want contact information. You can also find more about the Coalition on Human Rights First website by looking at the website or looking up Targeted Sanctions Human Rights First. We're here to help, so please don't hesitate to reach out, and thank you again so much.